Let's see, how much time I got? The one on the bottom, page 17, Town of Atkinson versus Melbourne Realty, is an enforcement case. It's sort of an interesting case, has several aspects to it, but I get this mixed up with a different case. Oh yes, they had a seasonal home. They wanted to convert it to a year-round home, and the zoning board granted a variance conditioned upon satisfying the fire chief as to fire safety. The fire chief said, you have to have a new driveway that reduces the slope to 10%, or you have to install sprinklers. They took that to court. They installed a driveway that had a 13.7% slope and no sprinklers, so they did not obey that the fire chief's requirements. And when they were taken to court for an enforcement action, they claimed that this order of the fire chief had violated the state law that prohibits towns from requiring sprinklers in 1- and 2-family dwellings. And there is such a statute, and it was just recently reaffirmed by the legislature. But the court said that statute had not been violated in this case because the town of Atkinson had not adopted a requirement, an across-the-board requirement for sprinklers. It was something that the fire chief had included as an alternative to what he really was requiring, which was a 10% slope driveway, and so it was upheld. The next one on page 18 has to do with what is required, what type of development is required to go through site plan review. The statute says, quote, the development or change or expansion of use of tracts for non-residential uses or for multifamily dwellings. This guy had a campground, had 10 units or 10 developed sites with utilities, and he said, well, it wasn't commercial. That was his argument. I don't need site plan because I'm not commercial, because I don't even charge these people. I just pass on the cost of utilities. It's basically a bunch of friends who come up and stay for the summer. And the Supreme Court ended up saying, commercial has nothing to do with it. The word commercial doesn't appear in the statute. The question is it non-residential? And they cited several dictionary definitions about the difference between somebody who was a full-time resident versus somebody who was a transient, as in the case of a campground, and so they said it is non-residential and therefore requires site plan review. The cases on pages 19 and 20 are about the lot merger question that we were talking about earlier. What constitutes a voluntary lot merger so that somebody is not able to apply to the selectmen to unmerge their lots that they claim have been involuntarily merged? Well, we learned from the Roberts case that tax bills alone have nothing to do with anything. The fact that you may have received a tax bill for one decade or something like that and failed to object to it does not mean that you have voluntarily merged your lots, at least not by itself. The other thing that doesn't constitute a voluntary merger or an abandonment of the lot line is the fact that you may have conveyed both of these lots in a single deed, especially if the deed continues to refer to them as Tract 1 and Tract 2. That is not a voluntary merger. In the Roberts case, though, there were a combination of factors which they found had been a voluntary merger. One of the things, I think this was the one where one of the, there was actually 2 or 3 lots involved in this, and there had been a garage built on one of the so-called lots in such a way that there was no way to get into it without going into the other lot. I mean, it was almost like you had built a building right on the lot line, so it couldn't possibly comply with any setbacks or anything like that. And there were several other things like that which convinced the court, based on a combination of factors analysis, that they had been voluntarily merged in the past by this owner. The Landrigan case was also a sort of an all of the circumstances type of decision. There was a recorded plan showing them as separate lots, but since that time there had been at least 3 plans that did not show a solid line between the 2 lots. There were several deeds in the chain of title that did not refer to them as separate tracts, but instead used a meets and bounds description referring to the entire parcel, the entire area. There was a driveway that crossed the line between the 2 lots, or what otherwise would have been the boundary line. And probably most importantly, the current owners admitted on the stand that they had believed when they bought the property that it was only 1 lot. So that combination of factors, I think this doesn't answer your question, but it's, you know, I think it's like a lot of court-made rules, which is, it's a combination of factors. but I think at least the one that is the clearest to me is a case like the Robillard case, which is cited in the Landrigan case, which is where the owner had built a building that was way too close to the lot line to comply with setbacks, and in fact the town administrator had notified the owner at that time that was basically going to constitute a merging of the 2 lots, and so that's the clearest kind of case.
Actually, in my case, we had a 3-lot, 3 description. Me and my wife mortgaged one and pulled it away, but when it sold, because the bank wouldn't mortgage the pit, so when I sold all 3 parcels, somehow we got merged. Floyd Sand and Gravel bought the whole.
By the town, by the tax collector.
Yeah, we get.
Well, again, but I think that the tax treatment by itself, the court has said, doesn't mean anything. So it really is an act on the part of the owner. Again, though, I only represent towns, so I guess the only thing I can tell you is that you need some legal advice. Let's see here. I only have about maybe 5 minutes at most. Let me go to page 33, because this is an important right-to-know case. I have included 5 right-to-know cases in this lecture notes, but this is the one I think that you really need to know about. Ettinger versus Town of Madison. And it has to do with, you may know that under the right-to-know law, a consultation with legal counsel is not considered a meeting at all. So you don't have to call, you don't have to notice it, you don't have to take minutes. But what this case is about was, what is a consultation with legal counsel? The Madison Planning Board had met to review some emails that their attorney had sent to them, and they were claiming that that was consultation with legal counsel, and the Supreme Court said, no, it's not. It only counts as consultation with legal counsel if your attorney is either physically present or at least available on a contemporaneous basis, like with a speakerphone, or, you know, maybe even on a live back and forth email. I don't know, but meeting to discuss a written opinion is not consultation with legal counsel. Now, the Madison Planning Board is not the only board that made a mistake with this. I was giving advice to a zoning board in a particular town in New Hampshire that about 6 months after this case came out, and they met to, I mean, they didn't ask me about whether they could, but they met to review my written legal advice. And they tried to pass it off as consultation with legal counsel, and I had to say, no, the Ettinger's case says you can't do that. And the only unusual aspect of it was that one member of that zoning board was a former Chief Justice of the New Hampshire Supreme Court.
What about a request to have counsel opinion on something?
A request by who?
By the board to have a council opinion on something, to talk to council about it? Would that be at a meeting, or is that something that's outside of it?
That wouldn't count as a non-meeting. That would have to be done in a meeting. You might be able to do it, again, you know, I'm not saying that every, every discussion of legal issues has to be public. There is in the right to know law a provision that says that you can meet in non-public session to discuss ongoing litigation, for example. So, but that is a little different because you have to post the meeting and then vote to go into non-public session. Now I want to go back to page 29 and talk about free speech briefly. I'm not sure why, but you know, a lot of towns have very valuable properties that are managed by conservation commissions or other land use boards, and there will be free speech rights. And this is a sort of an interesting case, if not comical, because the guy who brought the case had dressed up as Sasquatch and was staging a filming event at Mount Monadnock. And the state park manager threw him out because he didn't have an advanced special permit. And he filed a free speech claim, and the New Hampshire Supreme Court upheld the free speech claim. They assumed without deciding that the state park was a traditional public forum, meaning like a city park where people normally have the highest level of free speech rights, or like a city sidewalk or whatever. I don't know whether they would have upheld that if it had been questioned, but it wasn't questioned at the time by the state. And they said that the test is whether the regulation is narrowly tailored to serve a significant governmental interest. Well, the interest in this case was preventing conflicts of use among users of the state park. And they said it was not narrowly tailored because there are all kinds of uses that Mount Monadnock could have that would not interfere with other users. Like if 6 or 8 people want to go and pray on the summit, you're probably not going to interfere with other users. The other thing they said was not narrowly tailored was the fact that you had to get advance permission for virtually everything 30 days in advance. And the court said that there has to be some allowance for spontaneous expression, such as, for example, the spontaneous expression that we would all utter when we saw a Sasquatch coming down the trail. I think that's good enough. I won't get into the. I was going to talk about the takings case, but I think Dan's going to talk a little bit about that.
If we have time, we'll come back to it. I guess we'll take a short break.
Yeah, why don't we take 5 minutes?
Croc TV.